Hello, everybody. My name is Karen Tereposky. Thanks for joining us today. I'm an associate at Samfiru Tumarkin in Calgary. I'm here to answer some questions about your employment law issues today, and hopefully we can have a good discussion. I think we have some questions coming in already. Just as we're sorting those out, we can kind of review some news items, I guess, while I'm waiting for those to appear. Been a lot of tech layoffs in the news. That's an industry where there's been a lot going on, and employees there could look for longer severance packages, possibly just because there's such an inability to find other work. So I see we do have a couple questions here already. I'll just look over and see what we have come in. So the first question is about whether we take up American employment law questions. And we are a Canadian firm. Our lawyers practice in several jurisdictions across the country, and we can take questions from any of those jurisdictions. So Ontario, BC, and Alberta are where we practice and where we're licensed to practice. So US questions are usually you'll need an American lawyer. Sometimes there is some overlap, and there are some, if you live in Canada and you're working in the US, you may be subject to Canadian employment law. So it might be worth checking out to see if any of your questions are Canadian employment law questions. But if you know they're US questions, you do need a US attorney. We have another question. It looks like it's from YouTube, from Renee. She says, working at a company for 10 years as a major function of the business. Company wants to terminate older employees, so they force them to sign a 3-year fixed-term contract. Can the company then terminate after the 3 years without paying severance? So if it is a true fixed-term contract for the term of 3 years, then the severance is basically included in that 3-year term, and they don't have to pay anything additional. There needs to be an investigation, though, into whether that contract really is a fixed-term contract, because if somebody has been working for a company for 20 years and then all of a sudden they have to sign a fixed-term deal, it may be that a court would look at it and say, well, it's not really a fixed-term contract. You were subject to a indefinite term of employment, and this is just yet another piece of that puzzle. Also, there's a question whether that contract actually is valid. In order to make a contract valid to a current employee, an employer does have to give them some kind of benefit. So if they're giving this contract and the employee's not getting any benefit, it may actually not even be a valid contract. So best thing would be to have that contract reviewed by an employment lawyer to see whether or not there is an entitlement to severance or an argument that there's an entitlement to severance. Another question from Facebook from Haley. My employer does not provide staff parking. Is this something they have to provide? There's no legal reason why an employer has to provide staff parking. It might be something that was agreed to in your employment contract. And if it was, then yes, they do have to provide it as a term of your employment. But if it was never agreed to, there's no legal, statutory reason why an employer would have to provide you a place to park. The next question is from YouTube. The employer sent a letter letting me go for financial limitations. The ROE says code K. They told the stakeholders, other employees, that I left. No discipline was done on me. Can I claim damages? Well, if you were let go for financial limitations, that does sound like a without cause termination. If you have been terminated without cause, then you do have an entitlement to severance generally. Code K does mean dismissal, but it's subject to interpretation. Some employers just sometimes use the wrong code. So that doesn't really, it doesn't affect your legal rights, what your ROE says necessarily. If the termination was done though without cause, you should be getting some severance from that. And that would be your damages for a wrongful dismissal, because you're asking for damages. So from the looks of it, from what the facts are that you've set out here, it looks to me like, yeah, you should be entitled to some severance. It might be make some sense to go on and talk to an employment lawyer to see how much you are entitled to. You can reach out to our website and use our severance calculator. It's called our Pocket Employment Lawyer, I believe, and that severance calculator will give you an idea of how much you could potentially be entitled to if you pursue it. So we have another question from YouTube from Daria22. I've worked for my employer for the past 5 years. I recently went on parental leave and just returned back to work. Upon returning, the owner of the company said there might not be enough work for me to remain full-time, despite my manager saying the opposite. 4 weeks after I returned, I was terminated. My employer has had issues with letting go women on parental leave in the past. Is this a discrimination case? What can I do? It may be a discrimination case. So because of the proximity to the parental leave, it looks to me like it would be a situation where we could argue that your termination may have been motivated, and it only has to be motivated 1% by a protected ground, and in this case would be gender or family status. And that would make it a violation of the Human Rights Code or Human Rights Act, sorry. So if it was in fact motivated because of the leave and because of a protected ground under human rights legislation, it may be discrimination. What to do? You can contact us. We can look over some more details. I think there's obviously some questions that I would have to get into it a little bit more thoroughly to figure out whether or not we can claim discrimination, whether it's worthwhile for you. That's probably your best next step would be to reach out to one of us and have us take a look at that situation for you. I think the next one from YouTube is from Daria again, looks like the same question. So we'll just go to the next one. This one, when is a temporary layoff allowed and how long can it last for? Does receiving health benefits change the length? So temporary layoff under the Employment Standards Code, those provisions have just been revised a bunch of times for COVID. I believe it's 60 days or 90 days under the Employment Standards Code. During COVID, it was up to, I believe, 120, or it may have been 60 to 90 to 120. But there's only a significant or a specific amount of time that a temporary layoff can go for. And if it surpasses that, I'd have to look up if it's 60 or 90 days. Once that is done, then it's deemed to be a termination if you're not recalled back to work. You are right that if an employer pays for your health benefits during that time, and there's an agreement that does extend the term of the layoff, that it can go longer than that amount of time that's set out in the Employment Standards Code. If you are temporarily laid off, the employer has to include the provisions of the Employment Standards Code that relate to that layoff with your temporary layoff notice. So in that section, you should be able to look and see the length of the temporary layoff, the maximum amount. And like I said, it's either 60 or 90 days, and the exact number is slipping my mind right now, but it should be attached to your letter. And yes, it can be extended if they're paying for your health benefits. Next question is from YouTube from Kat. I brought up workplace safety concerns due to unsafe equipment. My employer removed me from the site I was on and lowered my hours significantly. Are they allowed to do this if I have expressed concerns about safety? So what you're describing may be a violation of occupational health and safety legislation. There is an action that can be taken under that legislation when an employer retaliates against an employee for bringing up safety concerns. So really, no, they're not supposed to retaliate by lowering your hours in response to a safety concern. What they're supposed to do is obviously investigate it and try to deal with it or have a committee to look at it. But I mean, obviously we'd need to have a little bit more information about how those relate to fully assess it. I do think that there's definitely an issue there, the way you've described it, though, and it does not sound like something an employer is able to do per occupational health and safety legislation. So thanks for that question. Next question is from Wendy on Facebook. She says, I am 63 and I have been employed since 2016 with the company. First as a product manager and now as a sales operation manager. The company has since been sold, and shortly thereafter, I was told by HR that my position was redundant. I was verbally told there would be an 8-month working severance offered with no other details. I've yet to receive anything. Is this right? If the company is giving you working notice of your termination, that working notice has to be given in writing. So your working notice period would not start until you were notified in writing that you were being placed on working notice of termination by a specific date. So they can't just verbally say to you that you're going to be given this and it starts. That working notice period has not started yet, unless you've been given written notice, and that's per the Employment Standards Code. The 8-month working notice period, though, would be quite low, I would say, considering it would be low in the circumstances. In a management position, I would suggest you take a look again at our pocket employment lawyer to see what comes up as your notice period, because employees over 60 generally do have longer notice periods. And as you're a manager, that also could contribute to a longer notice period. So 8 months may not be enough in your case. If they're giving you 8 months, you could potentially have entitlement beyond that once that 8 months is over, and you may want to pursue that either now or after the 8 months, if it's ever given in writing, because as I said, it doesn't start until you're given notice in writing that you're being placed on working notice. I have another question. It says, I've been working in construction, for the last 15 years. Getting a bit older and slower, my employer is saying I should retire. Can they force me out and onto retirement? No, your employer can't make you retire. Basically, what they're doing is asking you to resign, which they also can't do. You have to make that decision on your own. It has to be clear and unequivocal and voluntary. If you're going to resign or retire, it should really be your idea. Plus, if they are pushing you to retire based on age, that is, again, another violation of human rights legislation. They can't be pushing you on that basis. And if they force you out, if they say, okay, you're being pushed into retirement, that's a human rights violation. I would say there's likely already been a human rights violation if they're pushing. I would suggest keeping very good documentation of what the employer is saying to you and when. Make notes, write in a journal every time that one of these comments is made, so that you know exactly who said it, exactly when it was said, exactly what was said, in case you do need that evidence later on. I'd also say that, at some point right now, after they've been, suggesting this to you, that if they even terminate you without cause, that you likely still will have a complaint with the Human Rights Commission, because it looks like a decision to terminate even without cause would be based on age. So a couple things to consider there. Make sure you're documenting. They can't make you retire. That has to be voluntary. And if they decide to fire you, to eliminate your position, that's likely going to be evidence that it was related to age. So human rights violation. Lots of things to discuss with a lawyer, and I know those are likely really kind of foreign concepts that you might need some more explanation on. Obviously, I'm just sort of scratching the surface of what's happening with these questions. So, okay, next question is from Reddit, from Dee Dee. My employer has refused my return to work plan that my doctor provided. It outlined a period of time for set work hours over the next few weeks to accommodate a gradual return. My employer responded that they need a full-time return to work plan and denied having me back on the gradual return. Is there anything I can do? Can they require me back at full-time right away despite my doctor's recommendations, and just wait until I'm cleared for that instead? So again, a human rights issue. Employer is required to provide accommodations if there are medical reasons related to a disability. You've requested accommodation in a gradual return to work, and the employer needs to consider that, and generally has to provide it unless there's a very, very compelling reason why they cannot accommodate a gradual return to work, which usually there isn't. I suppose some industries it may be impossible to do part-time, but it's unlikely. So really the employer is likely failing in their duty to accommodate, which is a human rights violation again. What the employer should be doing is discussing with you how this should work and trying to find a solution. They shouldn't just be refusing that accommodation request. Like I said, unless there's a very valid reason, which it doesn't sound like you've been given one. So unless there's some reason why they cannot accommodate a gradual return to work, that is likely a violation of the Human Rights Act. We have a question on YouTube from Phil. My employer has placed me on a probation period after I have worked there for 6 months. Is this just a way for them to terminate me without paying severance? So under employment standards, a probation period can only be 90 days long. So you can't go back on probation and be terminated without any severance after 6 months. It's not legal. It's a violation of the Employment Standards Code. So if they're telling you that you're back on probation and then they do terminate you and tell you that they don't have to pay you anything, that's wrong. They do need to pay you for, as an employee who's worked their first 90 days and less than 2 years is 1 week minimum under employment standards. So they can't just after the 90-day period that you've worked there put you back on probation and terminate without any severance at all. There also could be a potential entitlement again to common law severance, which again, you could check out how much that could be on our Pocket Employment Lawyer or our severance calculator. Surprisingly, even after a few months, there has been a lot of recent decisions that have given pretty significant amounts of severance, even for short-term employees. So, just because you've only been there 6 months, it could be more than a week, it could be significant. There's even some cases that have said, kind of the starting point is going to be 3 months because that's how long it takes an employee to find a job. Realistically, you can't find a job with less than 3 months. So I'd take a look at that severance calculator. And, the basic answer to your question is no, they can't do that. So not legally anyway. Okay, so next question on, YouTube from Phil again. That's the same question. Okay, so next one is Reginald. I'm being loaded up with all of the management level duties without being given a new title or raise. They let go of a manager and said they aren't rehiring. Do I just have to accept the new duties? So you're describing basically unilateral changes to your employment contract. They're changing your role without asking you, right? You're not agreeing to it. They're just going ahead and changing it without your consent. So what that could potentially be is what we call a constructive dismissal. That could mean that basically they're violating the terms of the employment contract. So it's like the employer is terminating your employment without actually doing it, and that can give you an entitlement to severance. It's a bit of a complicated area of law, so I would advise you to talk to someone about it and give more details and before you go and do anything, like tell them that they've been constructively dismissed you and you're resigning. Get some more in-depth advice on that. But generally, an employer cannot make material changes to the terms of your employment contract. So if those terms that you are getting changed, if these duties are material changes, if they're basically making you into a manager against your consent, you could be entitled to severance. Now, unless you're ready to leave, it likely doesn't do you a whole bunch of good, because what you have to do to access a severance payment in a constructive dismissal situation is you have to resign. You have to resign and say, I'm resigning on the basis of a constructive dismissal, and then we can pursue severance on your behalf. But if you're not ready to resign and you need to keep working there, you can preserve your right to be able to do that by just making sure you're raising with the employer that you don't agree with the changes, that you're not condoning them, and that you're just continuing to work because they're paying you, and you need an income. So if you're being loaded up with all these duties, make it clear that you are not agreeing with the fact that this is happening. I'd suggest doing it in an email because it's documented. And then later on, if you do decide to resign on the basis of a constructive dismissal, we may be able to get you some severance in that situation. So hopefully that helped. It is a really complicated area, constructive dismissal, and that's just, like I said, scratching the surface of how to handle that situation. The next question is from, can't even read that name. I'm just going to read the question. It says, my employer told me I'm to be demoted and have my position changed, but will keep my pay the same. Now they say my new position only pays this much and that they can't pay me my old wage, 15.5% pay drop. So similar thing where they're unilaterally changing the terms of an employment contract here, and potentially a constructive dismissal. So material change to the terms of an employment contract often, we've heard in the past that it's 20% pay drop and you're saying 15.5. So, maybe they've read up on constructive dismissal and they're going, okay, well, we're going to keep it under 20 so that it's not considered a material change. But I mean, those numbers are guides, and it's not always the case that, it has to meet an exact threshold. I would say, especially because they're changing your position, a demotion in itself can be enough to be a constructive dismissal. So, you may have been constructively dismissed when you were demoted. Now they're changing your wage. That could be a second attempt at it, or a second situation where you're being constructively dismissed. So again, what you'd have to do is, make sure you're saying you don't agree with this, document that, because you don't want to be seen to have condoned this change that they're making without your agreement. And then, eventually, if you decide that, you want to resign and pursue this, that's one way to do it. Because in your case, your pay has been reduced, it's a little bit different because you are getting paid less, you are incurring damages even by staying on. So you could make the argument that the constructive dismissal occurred when you were demoted, and then claim the difference between the old wage and the new wage as you keep working. So you'd have to make the allegation that you've been constructively dismissed, but you're staying on in mitigation of your damages, which means, from that constructive dismissal, you've had a loss, right? That would be a severance, but you're continuing to earn by staying in that position because it's difficult to just quit and not have a job, but you could claim the loss that you have from your old wage to your new wage. Again, a complicated area of the law, and it's difficult to address in this sort of forum. But also, I find that people have a lot of follow-up questions when it comes to constructive dismissal, and if that is something that you'd want to pursue, I would urge you to reach out and talk to someone in more detail about your situation. Same person also says, I was demoted a few days after I gave notice for a medical leave. So yeah, and there's an element there of a potential human rights violation as well. Obviously, if it was motivated by that medical leave, then we're into a violation of human rights. If the medical leave it has to do with a disability, which is pretty broadly defined, but it does have to be something that's not sort of a transient condition. So if you took a medical leave for something, I mean, there was some debate back in COVID days about whether COVID qualified as a disability. So something, like the flu, you have to take a medical leave, maybe not a disability, but long COVID, I believe, has been held to be a disability. So if your medical leave has to do with disability, that's a protected ground under human rights legislation. If the demotion was motivated by that disability, then you have a human rights matter on your hands. Now, the next question from Dalton on YouTube. Are there any situations in which severance may still be owed past the 2-year deadline? So the 2-year deadline, I'm not sure if you're meaning the limitation period or the sort of notional cap on severance amounts at 24 months. So I guess I'll address both there. So there's a limitation period under which you can claim your damages for severance, and it would be 2 years that you can sue for a wrongful dismissal in the courts. So from the date of termination, you have 2 years to claim severance from your employer by filing a claim with the court. Those deadlines are absolute, and there's no discretion for the court to go back if you've missed that deadline. So if that's what you're talking about and you've missed the 2 years, no, there's no way around it. Okay, unless there was some issue of being incapacitated during the 2 years. If you're in a coma or something and unable to get legal advice, then maybe, but it's a pretty rare circumstance. The second piece, the 2-year deadline that I'm not sure if you're talking about, the way that severance is kind of awarded, what is sort of thought is that there's a 24-month cap on how much severance people will get. That's not exactly true. There are some cases in special circumstances where the courts have awarded more than 24 months severance in circumstances. Sorry, my dogs are barking. So it does happen in certain circumstances. Sometimes it's often where an employee has worked for a company for their entire working life, 30 years, that kind of situation where a court will go beyond 24 months. Okay, so hopefully I've addressed either of those questions. I'm not sure which one you were asking, but hopefully that helped. So another question from Sandy: when is an employer allowed to not provide overtime pay when working on holidays? Our employer has said our positions are exempt. Okay, when working on holidays. Well, we'll just deal with overtime pay. So there are certain positions that are exempt from receiving overtime pay under the Employment Standards Code, so which is time and a half, right? Certain positions like management positions, supervisory positions are generally exempt from overtime. There's some professional positions that are under statute, like the legal profession, engineers, those kinds of things. There's no time and a half for overtime hours. So that could be what it is. There's also an exemption for an employee who has access to confidential information. So a lot of IT positions are exempt from overtime because of that exemption under the regulation to the Employment Standards Code. So there are certain situations where employees don't qualify for overtime pay. However, that time and a half piece is only part of the equation. And if you're working overtime more hours than you've agreed to in your employment contract, you should still be getting compensated at your regular rate of pay. So maybe not time and a half, but you should for sure, even if you're overtime exempt, still be getting compensated at your regular rate of pay if you're working extra hours that haven't been agreed to in your employment contract. Question, I think this is a follow-up question about the medical leave. So is medical leave to have a surgery performed a protected right? Probably. Probably if you're having a surgery, that's likely going to qualify as a disability under human rights legislation. Question from Andrea: if you work at a company for 13 years, how much severance can you get? So years of service is only one of the factors that goes into how much severance is possible. Like I've mentioned a few times, that Pocket Employment Lawyer severance calculator is really valuable to plug your numbers in and your factors, because there are a few factors that are considered by the courts in determining how much severance an employee is entitled to. Years of service is one for sure. Age is an important one. Employees over 50 or 60 are generally entitled to longer notice periods. Employees sort of in their 30s and 40s can sometimes be shorter because they're more employable, in theory. And then availability of similar employment. So often management positions have longer notice periods because there's less management positions. Certain industries, people are just very easily reemployed. A lot of trades, for example, it's very easy to get another job, whereas there's some positions that there's just not very many jobs out there. So it does depend. I think a lot of people, kind of look at it like 1 month per year of service. That's not necessarily true. It could be more, could be less. That's kind of a rule of thumb, but it can be significantly lower, significantly more, depending on some of those other factors. So, punching your numbers into that calculator is helpful. Talking to an employment lawyer, because there's obviously some things that calculators can't do is really important as well. So it doesn't look like we have any more questions. I think that's it for today. So hopefully everybody got some answers to their questions. I hope I was of some help. Thanks everybody for giving your questions. Obviously it would be not a very exciting show if no one had any questions. So thanks for doing that and for listening, of course. Please join us again for our next show tomorrow. The 4th, it's tomorrow, right? Yeah, tomorrow with Samfiru, one of our founding partners. Thanks everyone. Thanks for joining us.